Do presidents have immunity from crimes? And if so, how far does that immunity go? The ruling will affect not only former President Trump, but future presidents as well. An attorney for the former president tried to convince the justices that he cannot be criminally prosecuted for any of his official acts while in office. CBN's Burke has that story.
The focus of the justices' questions to Trump's lawyer centered around how to make a distinction between private and official actions taken while in office.
In the special counsel's brief on pages 46 and 47, he urges us, even if we were to decide or assume that there was some sort of immunity for official acts, that there were sufficient private acts in the indictment for the case to go back and the trial to begin immediately.
The official stuff has to be expunged completely from the indictment before the case can go forward.
If you expunge the official part from the indictment, how do you, that's like a one-legged stool, right? Giving somebody money isn't bribery unless you get something in exchange.
On the question of immunity, Justice Sonia Sotomayor pointed out that the Founding Fathers considered including this protection for presidents and decided against it.
They had state constitutions that granted some criminal immunity to governors, and yet they didn't take it up. Instead, they pass an impeachment clause that basically says you can't remove the president from office except by a trial in the Senate, but you can impeach him after. Or you can impose criminal liability.
Michael Dreeben, the attorney for the Justice Department, expanded on that same argument.
The framers knew too well the dangers of a king who could do no wrong. They therefore devised a system to check abuses of power, especially the use of official power for private gain.
Dreeben argued the president doesn't need absolute immunity because layers of protections and legal safeguards are already in place.
The existing system is a carefully balanced framework. It protects the president, but not at the high constitutional cost of blanket criminal immunity. That has been the understanding of every president from the framing through Watergate and up to today.
Conservative justices questioned whether, without some form of immunity, existing safeguards would truly protect a president against maliciously motivated prosecutors.
The vast majority of attorneys general and Justice Department attorneys are honorable people, and they take their professional ethical responsibilities seriously. But there have been exceptions, right? Both among attorneys general and among federal prosecutors.
We are not endorsing a regime that we think would expose former presidents to criminal prosecution in bad faith, for political animus, without adequate evidence. A politically driven prosecution would violate the Constitution.
It's unclear when a decision will come down on this case, but it will likely be end of June, early July. Burke, CBN News, Washington.